Good afternoon, everybody. Thank you for joining us once again for our Senior Advocacy Forum. Like always, we're going to get started in a few minutes. I want to give a few minutes for people to be able to join in. All right. Thank you. Okay, everybody. So we're going to get started. I'm going to ask our guests to join us, both Peter and Rob, before I introduce them. Here we go. Okay. All right. Again, thank you for joining us today. Our topic in the Seniors Advocacy Forum is Don't Leave Your Loved Ones in the Dark, sharing your legal, financial, and final wishes with your family. This was an important topic for us to cover because all too often we'll be contacted by children and spouses, and they're not familiar with what is going on legally, financially, or even the final arrangements. So we've seen this happen all too often, which is why we brought in two experts to help us talk about not leaving our loved ones in the dark. All right. So let me introduce our first guest is Peter G. Maloney. Peter is a co-owner of the Maloney Family Funeral Homes located across Suffolk County. Peter attended the American Academy of McAllister Institute in New York City and then became a licensed funeral director and joined his father in the family business some time ago. Peter is an active member of the Knights of Columbus Holbrook chapter, the International Cemetery Cremation and Funeral Association, the Nassau-Suffolk Funeral Directors, the Metropolitan Funeral Directors, and the National Association of Approved Morticians. Welcome, Peter, and thank you for joining us.
Thank you. Thank you for having me.
Good. And then we also are joined by Robert D'Angelillo. Robert is a partner here at the Tully Law Group. He's been practicing law for 30 years with his focus on estate planning, trust and estate administration, and elder law. Prior to him joining our firm recently, he headed the elder law division of a large Suffolk County law firm after previously heading the trust and estates department at a different larger law firm. Throughout his career, Rob has handled surrogates court matters in both Suffolk and Nassau counties, as well as the city, and he's dedicated to assisting elderly clients to preserve their assets while obtaining the best care for their individual situations. We're grateful that Rob has joined us at the firm as a partner and also to have him here on the webinar. So welcome, Rob.
Thank you. Great. Good to be here.
Okay. Now, before we get started, for our guests, it's going to be similar to as we normally do it. Any questions, any comments, please feel free to leave a comment in the Q&A section or in the chat if that exists. I know we have the Q&A section here. But we're going to get started. If for any reason you can't hear me or see the screen, then please let us know. But the way this operates, it's going to be the three of us just having a discussion, a conversation about how we can make sure we're not leaving our loved ones in the dark. All right. So I'm going to have some questions for Rob, some questions for Peter, and then hopefully you'll all be learning from this as we move forward. If you again have any questions, feel free to type them in the box and we'll get to them once we're completed. Okay. So as an elder care law firm over here at Tully Law Group, we also focus on estate planning. So the first couple of questions are going to be for Rob. When we're meeting with clients, and of course, as they age, we're dealing with different circumstances and different layers of planning, so to speak. But what legal documents, Rob, should an aging client have in place as they're putting together their planning?
Sure. So we always say that there's some documents that every adult should have. And what happens is as somebody ages, they get tailored a little differently because the circumstances change.
Right.
So the four basic documents is a last will and testament. And most people know what that is. That's something that says, when I pass away, who gets my stuff?
Right.
But beyond that, it also says, okay, if I have people with special needs, if I'm leaving something to somebody with age restrictions, a minor, a grandchild, things like that, we want to have those provided for as well. And as people age, those circumstances change, so they might want to revisit those things.
Sure.
Next is probably one of the most important things is a power of attorney. And we stress something called the durable modified power of attorney. I've said many times, and I know Brian has said this too, I tell clients, if you're only going to do one thing I tell you to do, first of all, you should do everything I tell you to do. But if you're only going to do one thing, power of attorney might be the most important thing. Yeah. If somebody loses capacity, even if it's temporary, the power of attorney gives that agent, the person they name, the ability to handle all legal and financial matters for them.
Right.
The reason why we call it modified is New York State has a standard form, which, by the way, has changed 3 times since 2009. I think they got it pretty good now, hopefully. So, but, you know, we want to make sure that we expand on the powers. The basic one eliminates a lot of things that we think may need. And you know what? I have people go, well, when am I ever going to need this? I'm like, I don't know. If I had that crystal ball, this job would be easy. I said, but we want to have all those provisions. The big thing is it avoids a guardianship proceeding. A guardianship proceeding is lengthy, it's time consuming, it's expensive,
right?
And there's no guaranteed on the outcomes. I have seen situations where a family member petitions and the judge says, you know what, for whatever reason, we're appointing somebody off the court list.
Right.
So it may not go your way. Having the power of attorney, you're choosing who's going to be handling your matters. And on all these documents, we want to have backup agents so that, God forbid, something happens, you don't have to run back and get something redone. The next 2 things kind of go together. They deal with healthcare. So the power of attorney covers almost everything except healthcare. And the next thing would be a healthcare proxy. Healthcare proxy simply says, if I can't make a medical decision, this is the person I want making those decisions for me. The power of attorney, you can have multiple co-agents, things like that. With the healthcare proxy, you pick one and a backup,
right?
Another if you want, but we want to make sure, but it's just one individual person. Doctors don't want 2 family members, one saying do this and the other one saying doing this. They need the decisions made. So by statute, it has to be one person. And it's very general, covers all medical issues, including life-ending decision-making. However, we always want to have a living will. Living will deals strictly with life-ending decision-making. Says, in the event I'm unable to, if I lose mental capacity and I'm in what we refer to as a persistent vegetative state, and I'm only being kept alive by machines, I don't want that. So if those are your wishes, it's important to have that document. Backs up the instructions of the healthcare agent. I always say, keep it in the back pocket in case the doctor or the hospital says, for whatever reasons,
right,
we don't know if you knew what the issues were.
Sure.
So this way, it makes it very clear what their issues are in terms of those things.
Good. So those are going to be, like you shared, the 4 basic documents for every adult. There's another document that we do on occasion for certain individuals, which Peter's going to talk about. But so, all right, Rob. So the family, the husband and wife, the client, they put together this estate plan. We have this nice fancy binder that it goes in. Do they leave it on the kitchen table? Do they put it in the safe? Where should a client keep their original documents?
So I always recommend purchasing one of these fireproof boxes, safes.
Right.
You'd be surprised at how relatively inexpensive they are.
Mhm.
I've seen them at Sam's Club, Price Club,
Right.
BJ's. And you want to have them there. I always say, make sure your family members, that's what we're talking about,
Yeah.
know where the key is.
Yep.
Or have, some of them just have a code, make sure they're aware of that and make sure they know where it is. So if
Right.
you're not around to answer those questions, they know where it is.
Right.
This way, it's also safe at home. We tell people, do not put especially your will in a safe deposit box.
Yeah.
If you do that and they have to locate the will, they have to get a court order. If the bank finds out, and I've had people say, well, no, I have my son as co-signer on the safe deposit box.
Right.
If the bank finds out, and they do, there's methods where they find out that you've passed away. Even if somebody else is on it, they seal it, and you need a court order to access the box just to get the will. So you're doing an extra proceeding before you even started doing a probate.
Right. Right. Now, Rob, would you recommend that the client give copies of the documents to the client, or just know where they are?
It depends. Everybody's different. I've had clients that say, you know what? I'm doing this. I'll let them know where the stuff is. I do think that the agents should know that they're being named as an agent. Make sure, I'll tell you one example that I've seen happen many times. Somebody names one of their children as the healthcare agent, and it comes time to make a difficult decision, and they go, I can't do it. I can't do it. And so you want to make sure that you discuss what your wishes are with the agents.
Right.
And make sure that they say, okay, mom, dad, I'll do that if you need me to do it.
Right.
So, if you want to give them, I think it's a good idea to give them the actual documents, copies.
Right.
But everybody's feeling is a little different. At least make sure the agents know that you've appointed them, what's expected of them,
right,
and where the documents are.
Good point. So, we're, as a policy, we certainly advise our clients, power of attorney, that agent needs to know because they've got to sign it, healthcare proxy, living will. The last one, testament, trusts, those should be kept in the binder. Those should be kept in the safe. Those are your private wishes. You don't want to tell, child A is inheriting everything because you might change your mind, right? So those types of inheritance documents, you leave them separate, depending on the situations, right? Yes. Now, Peter, in your line of work, a very difficult line of work, you see people at times of sadness and tragedy. Is there another way to go about it? Is there a way that a family can actually say, listen, we've got this taken care of so that it's not a crisis last minute, so people aren't running around as to who to talk to? Is there a way to handle their final wishes in advance?
Yes, there is. There's advanced funeral planning is something that's very common today. And just like Rob said, I mean, a prearrangement, having a prearrangement in place basically just tells your family what you want done with your body after you're done with it. So if you think of it like that, it goes before the will. Okay. Nobody in my funeral, I've never seen anybody walk in with a will saying, oh, the wishes are in the will. Okay. Yeah. Wills are read after funerals.
Right.
Okay. So having a prearrangement in place and establishing what your wishes are really, really helps families tremendously. Additionally, you establish what your wishes are, but you can actually save money because we make decisions that are based upon what we want versus leaving the decisions for a family that's in grief. Interesting study finds also that when people suffer emotional trauma, okay, i.e. the loss of a loved one, their mental acuity diminishes by roughly 50%. That's a statistic from New York State Health. So, it really makes sense to make these decisions when you're healthy, when you're of sound mind,
Mhm.
and you can discuss it with your family if need be. But
Sure.
a lot of times people just come in, husband and wife, they make the plans,
Right.
put everything on file. That is the best way
Hmm.
to handle things. Two things that we see common when
Sure.
people don't have a plan in place: confusion and costs become an issue.
Hmm.
Okay. Two common threads that we see when someone does have a prearrangement is ease of service, and finances are relatively minimal because it's already been discussed on how the funeral is going to be funded.
Good, good. Now they can actually pay for it in advance as well, right? So it's all
Yes,
done.
we absolutely encourage families to prepay for funerals.
Mhm.
Okay. Um, let's talk about COVID for a minute.
Mm,
Okay.
sure.
COVID 2 years ago,
Right.
people that had prearrangements went to the front of the line. Had to.
Okay.
It was people that were prearranged, they got,
Right.
so, there's some benefit there. But
Okay.
yes, you can prepay your funeral. We establish a funeral trust
Hmm.
in the individual's name. It's
Right.
their money. It's their social security number. They get a K-1 at the end of each year,
Hmm.
reflecting the interest. It's fully revocable unless you're in an irrevocable
Right.
situation.
Yep. Right.
Okay.
Right.
But if you're living independently
Hmm.
without any state reliance, then it would be a revocable trust.
Right.
So
Right.
yeah, we put the funds in there, and that guarantees the cost of the funeral then
In today's dollars.
in today's dollars.
Right.
Okay, which
Right.
is pretty dicey for us. I mean, we've been analyzing those kinds of things recently because of inflation and consumer price index
Sure.
and everything. It's just it doesn't even sometimes even make sense. We used to do payment plans. Hopefully, we'll get back to that if the interest rates improve. But it's payment. You can open up the account with us. We
Right.
set it all up for the families.
Understood. So I could see the benefit of that. Now, we, as in dealing with elder care issues and often dealing with the Medicaid program, will recommend as a cost-saving measure, as an asset protection strategy, to go and prepay the funerals in full, because that's allowed in an irrevocable pre-need agreement, right? So, Peter, as you shared, I think that if we're not looking at any government program, you keep it revocable, and that way you can modify it and change it as you have to.
Correct.
Yeah.
The irrevocable, if you're in a Medicaid situation, you can pay for everything
Right.
except for lunch after the funeral. You
Right.
can pay for everything. You can actually pay for your children's funerals. You
Hmm.
can pay for their spouses,
Right.
the brothers, the sisters. You can
Hmm.
buy a grave. You can buy a stone. Okay,
Right.
so all of those things, and of course, every individual account would be set up as irrevocable. But
Hmm.
those sometimes that one particular thing where they don't realize that they can pay for other family relatives.
Hmm.
Uh, and if they're doing a spend down,
Yeah. Right.
I mean, somebody's going to have to pay for it sooner or later.
Yeah. 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 No, it all makes sense. And from what you're sharing is it's not just a Medicaid strategy, it's a good family strategy. And
Yes,
that way it's taken care of.
absolutely.
Now, what I'm going to do is, and that's why I wanted you on, Peter, is because of the need for the prearrangement, but also for this very important second point, which is that, again, keeping family out of the dark, making family aware of wishes. You strongly recommend that all people, as they're planning these situations, also put into effect a certain document that will involve the family. So, can you talk to me about the disposition document?
Yeah. So Rob was talking about before power of attorney and the healthcare proxy,
Right.
which are fantastic things. Highly recommend that you have them. But upon someone's death, those are no longer in effect. So now the right to control disposition goes back to the family.
Mm.
Okay, so there's an agent form that we strongly encourage families to prepare and fill out. This right to control disposition supersedes everything else.
Mm.
And in this day and age, the lifestyles and alternative lifestyles, and maybe there's somebody that is alone, or they need to have someone control the disposition, or
Right.
maybe there's someone in the family that they want to be in charge of the disposition. Maybe there's a family rift, or
Hmm.
people are arguing, or all kinds of stuff, or
Sure.
maybe there's a second marriage. or common is the common law wife or the common law marriage. That's not, that they
Legally,
can't use that in New York State.
right,
So it's not recognized. So if someone's living with someone for 20 years
Mhm.
and they're technically married, but they don't have the certificate, when
Right.
their loved one passes away, they have no rights.
Yeah.
This agent form gives them back their rights to
Mm-hmm.
control the disposition. And controlling the disposition is just part of it. Signing the document is one thing, but you need to have the prearrangement done, and then you need to pay for it. Okay,
Right.
that really solidifies it. That's secure. But if you make someone the agent and you don't have a prearrangement and you
Mhm.
don't have it prepaid, well, now you put all the burden on them, and that's not good. You
Right.
want to have your prearrangement done, and you want to have the financial aspect of it situated
Mm-hmm.
so that the agent basically holds the funeral director accountable to the prearrangement that you have.
Sure.
It's
And it's
an
all in writing.
accountability thing.
Yep.
Okay. And that's one things that we see often is when someone becomes the agent, is like, oh, I'm not responsible for any finances, am I? That's the first thing we hear. And of course not. We want them to pay, we want them to be paid. So you just telling us what to do. We're reporting back to the agent,
Mm-hmm.
telling them what we've done.
Right. So if you have, like you mentioned, that common law or a partner arrangement or a circumstance where you have a single individual, perhaps a widow or widower, if anybody just shows up, right? So let's say it's a common law spouse or it's a partner. If they don't have this disposition of remains appointment document, do they have any legal rights?
No,
They have none. So they can't choose, they can't select, they can't pick the casket. You can't even talk to
no.
them.
It goes back to the kids,
Yep.
brothers, sisters, there's the family hierarchy. So,
Right.
we often, I mean, sometimes we have that situation more times than we like. And
Yeah.
we speak with the companion
Hmm.
and say, well, where are the kids? Bring the kids in. Let's get the kids in and you come in with the kids.
Right.
So we try to navigate it that way, but that's not the best way to do it.
No, no. And because
The
if there's
best,
any type of dispute between the children and the companion, you have to listen to which party.
the children.
Yeah. Yeah.
The best practice is to have the agent form, have your prearrangement done. It eliminates so many things.
Mm.
Let's talk about a second marriage. How about that?
Sure.
Okay, where you got kids from the first marriage.
Right.
Now you got a second marriage,
Mhm.
somebody passes away, and the spouse
Right.
who's on the second marriage now stuck making the decisions, and
Hmm.
they're getting in, they got a bunch of kids from a
Right.
first marriage.
There you go.
They paint you
Yeah.
that picture.
Sure.
Okay.
Sure.
So if you have a prearrangement in a second marriage, or now you can say, well, everything's prearranged. I'm just following what your
Exactly.
dad's or your mom's wishes were.
That's right.
These were her plans.
That's
And
right.
now it eliminates that anxiety and stress
Hmm.
off the table because of that situation.
100%.
Many,
Agreed.
many emotional factors when it comes
Right.
to this.
Now, does the agent have to sign that disposition of remains form with the parent or with the one making the appointment, or they don't know about it till later?
No, the agent, the person making the appointment,
Hmm.
basically, we fill it all out for them, just like
Sure.
you prepare the documents
Yep.
for your
Yep.
clients. We fill it all out, and then the agent has
Mhm.
to accept responsibility,
Good.
and then the person appointing it has to sign off on it, and then
Right.
they need two witnesses. It doesn't even need to be a notary.
Okay, but the
You
point
don't
of
need
that and
to
the
notarize.
theme, the point of that and the theme of today is about not keeping your loved ones in the dark, is the person that's being appointed has to acknowledge it and they have to know what
Correct.
they're doing. So they're on board. And so as far as parents sharing with children, there you go. That disposition of remains form, they're involved with that. So they're going to have a copy of that. Like you said as well, Peter, you keep a copy on file.
Correct.
Okay, very good.
Keep
Very good.
everything on file. We actually give our families even an emergency contact card now, so that in the event somebody passes away, it's in their wallet next to their license. They can contact us immediately. So
Mhm.
we really tried to make it really simple for our families, but
Good.
it's super, super important that when they do have a prearrangement, and as we discuss things with them, We give them a nice packet. We bring this home. We put everything in our computer platform, but we tell them, make sure your family knows this has been done.
Right. Of course.
Because if they don't know it's been done, then they're not going to use it.
Right. And I'll even throw in there, it wouldn't hurt if it's done between you and the client and not the law firm, make sure the law firm gets a copy of it, because
Correct.
we usually get the calls towards the end anyway.
Absolutely.
Yeah.
Absolutely. We strongly encourage that.
Sure. So we've covered thus far, and there's 3 points for today. There's the legal, there's the final wishes, and then there's the financial, which we're going to get into next. But to recap a little bit, on the legal front, Rob spoke about the 4 important documents: the last will and testament, modified power of attorney, healthcare proxy, living will, and then possibly a trust, depending on circumstances. And then Peter, on the final wishes side, shared 2 very important points. The first one is to pre-plan and pay for those services so that your wishes are going to be followed. And then secondly, sign that disposition of remains appointment. It's what we call a DORA, D-O-R-A. Crucial information so that you can keep your family out of the dark. Now, Rob, to get into the financial side of things, all right? Now, we're not financial planners, but we are faced with these issues every single day. Because when it comes to planning a person's estate or even the elder care concerns, we have to know about the financial accounts. We have to know about the assets. So from that perspective, Rob, in your opinion, what should a parent or a spouse have in writing so that the survivors are a little more comfortable with what's going on and what the assets are?
Sure. And it's a great question. Now, what happens is when we meet with a client for a first appointment, we often send them a questionnaire.
Right.
And the questionnaire is asking, biographical information, who the family members are, things like that, a little bit about their health, but it also asks pretty detailed questions regarding their finances. I love that form for 2 reasons. One, it lets the client, as they're filling it out, go, oh, let me double check things like, who are my beneficiaries on things? I've seen situations where a married couple came in and they had a child, and the guy never changed his mother as his life insurance beneficiary when he got married. Figured, didn't even think about it. So it makes people think about these things.
Sure.
It also gives us information to look at, but I also tell them, look, once you have this filled out, keep this with your documents.
Yeah.
Because I can't tell you how many times, and I know, Brian, we get people come in after mom or dad's passed, and they go, I don't know anything about their accounts. I don't know where they are. I don't know.
We get that when they're still alive too.
Oh yeah, absolutely. Absolutely. Right. So, every day we go through that. Yeah. So having that is a good starting point, keeping it with your documents. So they say, well, this is what we knew. Updating it is also important. Yeah. So, we do tell clients that, not unlike a doctor where, you go for checkups every once in a while, not a bad idea to come in and talk to us, every 3 to 5 years, routinely. If everything's good, we're going to tell you that. If there's changes or recommendations, but that also gives you the opportunity to update. Banks change, names change as mergers. I get people coming in, they're like, Astoria. I'm like, yeah, Astoria doesn't exist anymore. So you want to update those things. This way, again, makes it so much easier when you pass for the family to administer these things. Right. So we also tell people it's a good idea to update things because, Saturday Newsday often has things about estates and elder law. When you read something, or if there's a change, grandchildren or somebody becomes disabled, come in and check those things. Life
events. Yeah, for sure. So what we often see is, and the questionnaire is a great point, because our questionnaire is a little thorough, and we're not doing it to make people give them extra work to do. Life is difficult enough, but what we're doing is we're doing it for the exact reason you just said, because at the end of the day, you're going to have one location for financials and different accounts. Now, that questionnaire doesn't need account numbers, doesn't need all that. You keep that private, but at least it's a place for the kids to start to look. Correct. Now, apart from that, what we've recommended through the years is it could be a spreadsheet, right? If you're going to do that lockbox you mentioned earlier, Rob, with the legal documents, put in a spreadsheet that you can update with the institution, the type of account, the approximate balance, the account number, contact phone number, the joint donor, beneficiary. For example, that's a great way to track all that's happening. And as you said, every couple of years you take a look at it, or if there's certain life events, births, deaths, illnesses, certainly a good time to start reviewing those things.
Yeah.
Um,
And just, let me just add,
Yes.
because there are some clients who aren't tech savvy and they, oh, I don't know how to do a spreadsheet. So again, if you get somebody to help you, but also keep statements, just a recent statement or an end of year statement.
Yeah.
Life insurance, they'll usually send you quarterly statements,
mhm,
cash values and things like that.
Right.
You don't need 20 years worth of statements to keep,
Yeah.
but keep the most recent ones and periodically update and keep that with your other documents so they can see what's going on.
That's prudent. And in that folder, you'd also have Peter's pre-need set up funeral arrangements. Now, as far as sharing this with the family, I would agree 100% wholehearted. You put that in that lockbox so that it's in there so the family knows how to access it. But as we get older, perhaps you're a widow or a widower, there may come a time you're going to want a child on those bank accounts with you. So if there's a trusted child or a trusted friend, they might be your power of attorney agent anyway. So you want to bring somebody into the fold as far as knowing the location of the assets, how to access them, maybe how to access computer passwords for software, for QuickBooks, for Facebook, all of that type of digital information, so that at least one person knows where it is or how to access it. Okay. Certainly not saying you give them all your passwords while you're still alive. You just let them know where it is in the house. And then if it's in the house, you got to make sure they have a key to the house or how to get the key into the house. Like my own folks, whenever they go away or as they're getting older, I know where the key is. I know where the alarm system code is, and it's a way we have access. It's that closet in the den, right? Now that everybody knows they got to move it. All right. So, but it's having that conversation with your children and your loved ones. And again, not necessarily all of them. And you don't, as I say as I said in our social media posts, you don't have to share everything with the kids and all of the kids, but you need to share the basics. Okay. And I think we've covered that today, and I'm grateful everybody's been able to attend. Peter, did you have anything else that you'd like to add before we get to the questions?
Yeah, I just wanted to just make one other point too,
Sure.
really clear. The pre-arrangement services are a free service.
Mhm.
It doesn't cost you anything to come into a funeral home
Good.
and get the information that you want. You're entitled to a general price list. So if you walk into a funeral home and say, hey, I'd like to get some information on funerals,
Mhm.
they're required, the Federal Trade Commission requires that they provide you with the general price list.
Mhm.
Okay, now they'll hand it to you and that's fine, but that's a requirement. So you're entitled to the general price list, but you also can get a free estimate. So, and you can pre-arrange your funeral. Many families, especially the people that are getting up there in age, have planned and bought insurance
Mm.
for their final wishes expenses as well. So,
Mhm.
so paying for a funeral is strongly encouraged, but there are instances where people come in and they just make their pre-arrangement, they make it known to their family, and they provide us with the cover page of the insurance. We know that that insurance is going to cover and fund the funeral at the time. As long as the policy's in force at the time, then we move forward. But most importantly is having the plan in place.
Good point. Good point. Rob, any last comments before I check out? Any questions?
No, I think, again, sharing the information, just as you said, I couldn't agree more.
Mhm.
And, with the explanation of make sure that they know who to contact and those kinds of things.
Yeah, good. Now, and just as a last point, again, before I get to the couple of questions we have there, if you have questions, folks, please go to the Q&A box and enter the questions, and we'll be happy to answer them. I would say that if you're the client, or if your parent is going in for a procedure or a surgery or moving, that's a good time to say, hey, listen, let's update what's going on. Going on a vacation, going on a trip, visiting family. That's a good time. Obviously, you're going to, hope for the best, but you got to plan for the worst. So it'd be important to have that updated, all right, should some kind of surgery, procedure, or travel occur, all right? Now, questions. So the first question is, How does an Article 81 proceeding, Rob, affect planning ahead? Right. So I guess so. An Article 81 is a guardianship proceeding that would be necessary if an individual has lost capacity without a power of attorney or with a power of attorney without the right modifications. Okay. So this is a worst case scenario. So Rob, if somebody is subject of or subject to an Article 81 guardianship proceeding, how can they go ahead and plan, pre-plan?
So again, the power of attorney is very important. I'll give you, doing this for so long,
Yeah.
you get little examples. I'll never forget. Somebody had a power of attorney, but it didn't provide for transfers to trusts, didn't provide for gifts.
Yeah. Right.
And we had to go and do an Article 81 proceeding just to transfer the house to make the person eligible for Medicaid.
Right.
So again, delays, expenses, things like that.
Yep.
So you want to avoid the Article 81. Now, if there's something that's not done, you can do the Article 81, and sometimes it can be very specific, like I just mentioned, or generally. And the Article 81 proceeding is very comprehensive. So when you see those petitions to the court and the order to show cause in the petition, several things. But again, doing that power of attorney can avoid all that.
Sure. And what I would say is if there is actually an Article 81 in process already or already in place, that it's going to, any type of expenditure like that is either going to be requested in the original court order appointing the guardian, or it's going to be requested by the attorney after the fact. The judge would have to approve that type of an expenditure.
Right.
So Peter, question about what happens to the funeral prepayment should the funeral parlor go out of business? Can it be transferred, that type of a situation?
That's a really good question, and that's a very common question. So thank you for asking it. If the funeral home were to go out of business, the trust is separate. It's not in our operating account. We have to account for that money. Okay, so that trust is set up in the individual's name under their social security number, under their date of birth. It's their money. They get the K-1 at the end of the year, so it's fully revocable. Now, better scenario, better instance maybe, what if the company is sold? Suppose we sell the business to somebody else.
Right.
Well, in that instance, we have 30 days to send out letters to everybody notifying them that there's been a transfer of ownership to an outside entity. Okay, at that point, they then have the right to revoke the trust. Even if it's irrevocable, it's still portable. They can transfer it from one funeral home to another. They just can't touch the money. So it's fully portable, even if it's irrevocable. Revocable, they can pull it back. But in that instance there, most of the time, in my experience, when a purchase has been made, just as we've purchased other funeral homes, we've sent out the letters, we've had conversation, people are concerned about us honoring the prearrangement, and that's what we do. We honor the prearrangement as it was written. We stand firm behind that.
Understood.
That's basically how it works.
Good. And as you know, your reputation would dictate, that's what you guys are going to do.
Bottom line is, family is in control.
Understood. Right. And if there is, God forbid, either a sale or something's going on financially with the business, it doesn't impact that separate fund. Right. Yep. And a follow-up question by the same questioner is, since there's a K-1, and I'll just answer it, it's not that there's no separate trust for the funeral arrangements. This is a statewide trust that you're joining.
Correct.
So the K-1 just means that they're going to pay interest on their personal tax return for that amount.
Correct. Because if in 5 years they turn around and say, I'm moving to Florida, I want my money back, I got to give back all the money plus the interest.
Right.
I don't make not one penny on this trust until the event takes place. So that's why they pay the tax on the interest.
Understood, because it's theirs.
At the end of the year. So
Got it.
all depends on what their tax brackets are.
Got it. And then I've got two questions about needing a trust. I'm assuming more on the irrevocable asset protection side, because the follow-up is talking about protecting money and getting it out of your name. Phyllis, I'll answer that briefly, but our website, tullyelderlaw.com has a whole host of events and past webinars that talk specifically about asset protection and irrevocable trusts. You're more than welcome to go catch those this afternoon and get all of that information. But generally speaking, anybody over 65 years of age that we meet with, that's when we want them to start protecting their assets for the future. All right. So getting money out of your name, you got to be careful with that, because you just don't give money to children, because bad things can happen to them, God forbid, and then there goes your money. So it all needs to be a part of a coordinated plan. All right. Another question for you, Peter. Do you have to, I'm going to assume, pay the entire cost of the pre-planned funeral?
No,
Okay.
no, we have families that open up a trust account for $300.
Yeah.
And they put money in whenever they have extra money. The purpose of prearranging and prepayment, as I tell many families, is that this is supposed to give you peace of mind. It's not supposed to create additional anxiety about another bill that needs to be paid.
Yeah.
So if you can pay it, great. If you can't, and you just want to open up an account and start adding money to it, there's no guarantees at that point, but you can begin to squirrel some money away for the inevitable time when your family's going to need it. So we set that up. We have families that people come in, give us $100 a week or $100 a month, or they pay it all at once. And so we set it up, whatever is going to be best for the family. This is about the family, not about us. It's about peace of mind, taking care of the family. That's one of the things my dad always told me. He says, take care of the families. Do right by the families. Everything else will take care of itself.
Amen. Very true. Very true. Another question about I already have a trust. My husband has passed. Do I need to remove him from the trust? Again, somewhat of a different topic, but the answer, Wendy, is you do not need to remove him from the trust. The trust should accommodate that contingency. Thank you, Bonnie, for joining us. Question, Peter, how do we coordinate the funeral home with the burial site and the family? That's the question. So how does all that get coordinated? I guess if you're in charge of it all, or they're working with you, you'll handle it all.
So when a death occurs, you need to notify the funeral director. The funeral director then will receive the individual into their care. There would then be a meeting to discuss and put together a timeline of events that will take place to fulfill the prearrangement. And the funeral director will schedule the mass or schedule the cemetery and schedule the gathering. They should post all the information on the websites. This is all done digitally now. We actually send all this stuff out to the families via email so that everybody is kept in the loop, and communication is on point for everybody to know what's going on.
Good.
The funeral director handles everything. We handle everything.
Yeah, agreed. And we've seen that. Another question for you, Peter. Are there any limits time limits as far as the pre-plan? Can a 25-year-old walk in, lock everything in, and not use it for 60 years?
Yeah, there's no time limit.
Got it. All right.
No, I haven't had any 25-year-old come in yet, but 40-ish.
Yeah.
38. Some guys going overseas. Some guys going overseas have come in and made their prearrangement with us. So there are instances. So, you take those things into effect. People live, different lifestyles, and, they're jumping out of planes and things. It makes sense to, hey, let me get things in order. But yes, so there's no limit.
Got it. If you do revoke the pre-plan, are there any penalties, or do you get it 100% back?
No, you get 100% back.
Okay.
In New York, every state is different.
Fair.
Florida's a different. Different states are different. New York State, 100% revocable. You get all your money back plus all the interest.
Good. Last question is, what happens if somebody dies without a will? Again, a little bit of a separate issue, but it's what's called an administration proceeding. If somebody passes away with assets in their name alone, that's when you have to go to the court for either a probate proceeding with a will or an administration proceeding without a will. Generally, as a good planning idea, is we like our clients to avoid probate. We want to keep our clients out of the courthouse, whether it's that probate proceeding or that guardianship proceeding we spoke about earlier. All right. So with that, thank you, Peter. A real pleasure. Thank you, Rob. I think we got some good information out there as to what to get done and who to share it with. And thank you, folks, for attending. Any questions, please feel free to shoot us an email, and we'll be happy to help moving forward. Join us next month when we do another Senior Advocacy Forum, and we'll see you then. Thank you, Peter.
Thanks, Brian.
Bye-bye,
Thank
Rob.
you. Thank you,
Brian.
Rob.
Thanks,
Have
Brian.
a great day now.
Bye-bye.